Jordan Lamonde is not guilty of second-degree assault. The simple assault is not guilty of second-degree assault. In order to find Jordan guilty of second-degree assault, the state must present evidence and prove to you beyond a reasonable doubt that he was aware of a substantial and unjustifiable risk, that he consciously disregarded that risk, and that he acted with extreme indifference to the value of Erin's life. Not just extreme indifference to injury, not extreme indifference to her safety, not even extreme indifference to serious bodily injury, extreme indifference to her life. The judge will instruct you. It's a blatant disregard for her life. And what that means is a blatant disregard as to whether or not she still would have been alive after that altercation. And the facts in this case don't support that. Simply, frankly, no evidence to support that. Now you heard that Jordan stipulated that he's the person in the video. He admitted, I'm the person in that video. And what Erin told you is the video shows all the contacts that Jordan and Erin had. The rest of the state's case, it's all for show and theater. Let's talk about some of the witnesses that the state put on. We had Detective Livingston. He came up, he took the stand, he had his gold badge around his neck, and his sidearm on his side. Did he witness this assault? No. Did you learn anything from him? Then we had Detective Bork. Remember, I asked him some questions about whether they checked Jordan's hands for injuries. He didn't really want to tell me that. Eventually, he reluctantly agreed that Detective Emerson did that. Kind of vague, though. But you got to remember, Bork and Emerson made a special trip down from Rochester to Portsmouth to see Jordan. They were investigating this case together. They were side by side when they were talking to Jordan. Detective Bork knew that Detective Emerson looked to see if there was injuries on Jordan's hand. And he knew that he looked to see if it was for a reason. Because if there was injuries on the hand, it might support the state's theory. But then Detective Bork said, well, that's not really a big deal. It's not a big deal because there wasn't any injury on Jordan's hand. It wasn't a big deal to Detective Bork because it didn't fit the theory of the case. It actually undermines the state case. So we'll just get rid of that and say it's not a big deal. And then the state brought in Officer Mervyn. And she testified to you that Erin McCarthy was so upset that she couldn't even talk, that they had to move her to an entirely different location just so she could speak. Well, first of all, you never heard Erin say that. And then when I asked Officer Mervyn about that, I asked her if that was in her report. She said she didn't know. I asked her if she read her report to prepare her for her testimony. She said yes. And I asked her if it's in her report. I don't know. I show her report. I ask her again if it's in her report. She tries to dodge the question and not give you all the straight answers to the question I'm asking. I asked her 3 times before she finally concedes that the thing that she is testifying about is not in her report. Again, it's this pattern of overselling and exaggerating the facts in this case. So, the state calls those witnesses. But you heard that Erin went to Frisbee Hospital. When you go to the hospital, presumably you see a doctor. The state called the doctor and said, ask them, is this risk to Erin's life? Is this a blatant disregard for her life? No. Because the answer to that would be what we already know from common sense, is that this was not a blatant disregard for her life. The prosecutor asked a question, a rhetorical question in opening statements yesterday. And that question was, why are we here? That's a good question. Well, the defendant admits he's the person in the video. Aaron McCarthy says the video is all of the contact. The defendant admits that he should be found guilty of a charge of simple assault, which is a criminal charge and punishable by incarceration. So why are we here? Let's answer the prosecutor's question. Why are we here? We're here because the prosecutor is overreaching in its attempt to convince you to convict Jordan Lamonde of a second degree assault. While we're talking about the opening for a moment, you gotta remember, I mean, how many punches did the prosecutor tell you about in opening? Because first it was 40, and then it was 40, and then it was 40. Down all over the place. And then the prosecutor stood here, looked you all in the eye, without any equivocation whatsoever, and told you that that video would show that Jordan kneed her directly in the face twice. He didn't have any hesitation about telling us that. Look at the video closely. Maybe my eyes, or maybe I watched a different video. You can tell that there's some contact between Jordan's knee, and Aaron's body, but you can't tell where that contact is on Aaron's body. It's not directly in her face 2 times. What else do we know? What do we know about the injuries to Aaron? Is her nose broken? Is her nose bleeding? Is her nose swollen? Aaron never testified that she was kneed in the face. Look at the video. Again, it's a pattern of overselling this case. But the prosecutor's hedging his bets. The prosecutor also brought the 3 misdemeanor simple assault charges. Because in the car salesman analogy, he still wants you to buy the car, even if you're not going to buy the expensive floor mats, the extended warranty, the paint protection, and the maintenance. This case is about the facts, and the facts really aren't in dispute. The facts are all on the video. No weapon was used, not a gun, not a knife, not a blanket. There were no threats, verbal threats on her life. Jordan never said, I'm going to kill you. He never spoke with her at all. This altercation ended because Jordan ended it after 28 seconds. Police sirens weren't in the background. Blue lights weren't in the background. No one was pulling him off. No one was driving into the parking lot and scaring him. He had ended this encounter on his own. He left her in a place of safety. No one died. No broken bones. No surgery, no stitches, no casts, no crutches, no serious bodily injury. The only treatment that we heard about was cause for the superficial cut. And the EMT, who testified just moments ago this morning, he arrived on the scene like within minutes of the end of this altercation. No loss of consciousness. Completely normal neurological exam. Her breathing was normal. Her eyes were normal. He was alert to person, place, and time. Completely normal pulse. No changes in her vision. No nausea. No dizziness. No weakness. No issues with her neck, chest, abdomen, or back. And when Aaron gave the interview to WMUR a few days later, says, I'm doing okay mentally, or excuse me, doing okay emotionally, doing okay physically. state has brought this charge of second-degree assault. The state has the burden of proving it to you beyond a reasonable doubt, every single element. And the state can't do that with the facts in this case. All I ask of you, all Jordan asks of you, is that in your deliberation you follow the judge's instructions on the law. Hold Jordan accountable for his completely inappropriate and completely unacceptable reaction to being the victim of a crime. Find him guilty of one simple assault. Follow the law and find him not guilty on the second degree assault. Thank you.